Okay, so hi everybody. This is a long-awaited interview with John. He is a constitutional lawyer with expertise in the oath of office, and I'm very pleased to have him here. He's going to talk with us today about how Americans can wield the oath of office to have oath-violating public servants removed from office. It's really exciting. So, hi, John.
Hi, how are you?
Pretty good. How are you?
All right, party.
Great. Well, why don't you tell the listeners a little bit about you and your background, maybe how you came to be an expert at the oath of office, and maybe a little bit about the booklet.
Okay, many years ago, I had a mentor in law. His name was James, and we actually filed a lawsuit against President Bush.
Wow.
And it actually took me 8 hours. And when he looked at it, he took a 4-inch by 2-inch stamp and stamped rejected.
I want to focus on what we talked about with the oath of office procedure.
Okay,
If that's okay with you. And I want to, I know we don't have a ton of time tonight, but I feel like this is a very important interview. I'm really excited to be having it. But I know there's a million things you could talk about since you've got a lot of experience and knowledge. So I just want to kind of hone it down on this one thing and for now. And we can talk about other things going forward in the future if we decide to do more interviews. But why don't you tell the listeners a little bit about the Vultures booklet, just in the sense of Milt and how you met Milt, and what is the significance of the Vultures booklet? What is it? And if you could briefly tell us, and then
right,
we'll get into the steps that we're going to
right,
cover
yeah.
today.
That's what I was going to do right next afterwards. Okay. So I met Milt over 20 years ago, and he had talked about the oath of office, and he was talking about getting it published, and he was kind of dancing around with prices and this and that, and I thought, no, we got to get this done. I didn't realize at the time how important it was. I know now that it was extremely important. And so in 2001, we filed the oath of office, and not filed, but in the Vultures booklet. He created what's called the Vultures booklet, and it set out how we're screwed over by almost every single agency, and there has to be a remedy in law, otherwise we're going to be killing each other. So, and the public servants have an obligation and a duty to follow the law as it is written under the authority of either the United States or the people of the state of California or whatever state you're in. So they have obligations and duties. They have to take the oath. In California, they have to take an oath to do two things: support and defend. Support means support in terms of thought, word, and deed, which means they have to, uh, every thought they have, every word they speak, and every action they take must be in accordance with the oath of office. And when they don't, they must be removed from office for the rebellion to the oath that they took. That's where the writ quo warranto comes in.
And I just want to jump in for listeners just to make sure you understand this is not just applicable to California. This is actually all the states in the United States of America. The booklet was originally published in Oregon, and we're working on getting a booklet published in all 50 states. We're going to start with California and Texas because that's where we are. Carry on, John. I just wanted to make sure people understood that.
Yeah, that's fine. Yeah. Yeah, you're right. It's not just for California or Texas, it's for all the states.
And Milt
When,
published this booklet in Oregon, wasn't it like 8 days before 9/11? And he had a call from a senator.
yeah, some of the local politicians there told Milt, Milt, you don't know what good you've done for this. You caused a lot of problems. This cost us a lot of money. But when this booklet was used in court, some judges ran out of court and were gone for 2 weeks. Some judges took an early retirement, and the Chief Justice, Wallace Carson, was essentially fired. So what that means is he was told either you retire or we're going to fire you.
And
So
we sorry, John, I didn't mean to interrupt. I just wanted to let listeners know Milt, the author, has passed away as of June of 2025. And, before this, several years before this, John and I had worked together to try to get the booklet in the hands of people and to help them understand how to use it and all of that. So that's what this is. It's a carrying on of the legacy that Milt left. And I have permission from the author to distribute this booklet, the Oregon version, and it is available on the website that we have, and it's thevulturesbooklet.com. It's available there if you want. But John, why don't we dive into this process that I'm so excited that we now finally have spelled out for Americans? Now, I'm going to read this to you guys. And John, if you hear me say anything that's not right or I'm missing something, if you wouldn't mind diving in, just jumping in and just kind of correcting me. But in this, for the sake of time, I'm going to try to just read through this. I tend to take pretty good notes, I would hope. But if I've gotten anything wrong, does that sound good to you?
yes, go ahead.
Okay.
Good. Yeah.
Great. Okay, guys. So this is long awaited. I have been wanting to do this for years now. I'm so excited to present this to you. So I'm gonna give you some steps here. I've broken it down, and I'm gonna make this available in some form that you can get from our website in the future. But right now, I just want to go over this. So you're gonna start. This is step one. You're going to serve the public servant with what's called a writ of quo warranto. And John mentioned this a little earlier. The writ of quo warranto, it asks the specific question of the public servant who has violated their oath of office. It's going to ask them, by what authority do you act? And if they didn't take the required oath, they're not going to be able to answer that because they do not have the authority to act as a public
Yeah.
servant.
Or if they have taken a bastardized form of the oath.
Exactly. And the example you gave, I'm not going to name names right now for the sake of well, it should be obvious, why not?
Yeah.
But there's a public servant that he left out this John, you actually looked up his oath and found a copy of it in it, and you found indeed, and this is amazing. I mean, this is a violation of the law. This public servant, and he's a fairly prominent public figure too. He has a lot of power. He left out the second paragraph of his oath of office. And that second
Yeah.
paragraph, John, why don't you tell them? I have it written down here, but I'd like to hear you tell them what does that second paragraph of the oath of office say that he needs to do?
It reads, and I do further swear or affirm, and they don't do that either. That's another violation, that I am not a member of any organization, political or otherwise, that advocates the overthrow of the government of the United States or of the state of California by force or violence or other
Awesome.
unlawful.
Yes. And so what's so amazing about that is that this person, which we're not naming names purposely right now, they have, in fact, multiple times now taken actions that would indicate that they are a member of such an organization, which explains why perhaps they did not include that second paragraph in their illegally filed incomplete oath. Okay.
Yeah. So
So,
someone with a brain would think, oh, they must be taking an act to overthrow the government of the United States or the state of California by force or violence or other unlawful means. That's
right.
really bad.
Right, right. And so a lot of people are pissed off. A lot of people feel disempowered. A lot of people don't know what to do. A lot of people have been brainwashed and disempowered to think that we can't do anything. And that's what this whole interview is about. And that's what this work is about. So let's continue now that you have that kind of example in your heads to understand kind of what we're talking about here. So in your writ of quo warranto, or actually rather alongside your writ of quo warranto, you're going to do what's called a statement of facts and a chronology of events. And it's just a Word document. You can put it into the form of a letter. You don't need to have like salutations and all that, but you can write it in a Word document. And you're going to say essentially, on this date, so and so, you were required to take this oath and you didn't. So, by what authority do you act? And you're going to include that letter or document that you're going to write with your writ of quo warranto. And then you're
Yeah, and
going
you want to,
to,
excuse me, and you want to get the evidence of the oath. You want to get the evidence of the oath that they took, and you want to get the oath that they are required to take, so they can put it side by side and compare it and see the difference.
all right. And I am writing this down as we go. I'm adding this to my notes because that is important. I am trying to be very thorough with this process to make sure that all Americans have, they don't really have a lot of questions, that this is laid out for you to follow. Perfect. So you're going to take that statement of facts and chronology of events, you're going to add that to your writ of quo warranto, and you're going to include then your evidence, which uh, is going to be composed of the oath that they were required to take. So in every state, there's slight variations, but it's essentially the same. You're going to uphold and defend this Constitution against all enemies,
Yeah,
foreign and
support,
domestic.
support, and defend.
Support and defend. And then you're going to show the one that they did take, and that's going to be the flawed one in this particular example we had given you. This public servant did not include the second paragraph of the required, binding, legally required oath. That is their violation of the law, and that is how you're going to get them removed from their
Yeah,
office. Okay, that's
right.
what's so
So
powerful about this process. Okay,
right.
you're
So
going to
either
have,
so
I'm
either,
sorry.
excuse me, either they have taken the complete oath. There's two paragraphs to it, or they didn't, or if the whole thing is bastardized. Those are different reasons for doing this.
Yes. Okay, and how are you going to process these? You are going to have both of these with your evidence served by a process server, or you can have a friend do this. And what they're going to do is they're going to hand these documents to the public servant now at their place of business. If the public servant is a judge, you would hand it to the bailiff. Okay.
Yes. Yeah,
And it's
do not attempt that in court to
right.
go up and hand it because they'll arrest you in court.
Okay, and then that's kind of important. And so you're not going to court yet. You're literally just filing documents. You're having documents served, rather. Okay. You are not going to do this yourself. You're going to have a process server or a friend do it. Okay. Um, it's going to say something like, on this day, XYZ happened to me, whatever it was. And the examples you had given me when we were talking earlier, John, were a little more personal. We're going to go up against these people who violated their oath, and this is how you were personally damaged. This has to have a basis in law violation by the public servant, and that violation would be their violation of the oath of office. And you just have to show how you've been damaged, which is, I think, a very clear thing to show. Okay. So what you're going to do next, once you've served these papers, or had them served rather, is you're going to wait for an answer, and you can give the public servant any amount of time you want. 7 days is fine, 14 days, 30 would be fine too. They're not going to probably respond because they don't have any authority, because they don't have a correct oath filed, or they've violated the oath. And so you're probably not going to get an answer. After this period of time that you've set forth to wait for their answer, you're going to go into court and you're going to sue this public servant. And this is going to be an individual lawsuit, not a class action, because the violation that they've committed is going to affect each person differently. Unless a whole bunch of people have the same problem. And I believe, John, maybe you can correct me if I'm wrong on this, but I think nationwide, you have to have a minimum of 30 Americans with standing to file a class action lawsuit. Is that to your
Yeah,
knowledge?
that's a whole nother different thing. It's
Okay.
yeah, just you can
So
leave
we're
that
gonna,
out. But
s- okay, so we're just gonna stick to, you're gonna be suing them individually, and you're gonna be pursuing this, you're the damage to you as a person, not as a class action. Okay.
right.
And you're probably not going to use a small claim either. It depends on how
No.
you were damaged. Um, okay, if the public servant does answer, it's going to trap them because they have no authority. So you're going to want them to cite a law that supports the mandate. Can you just explain that real briefly, John?
Well, what they do is they'll use case law, but there's no authority in case law. When you go to the supremacy clause, it says this Constitution and the laws of the United States, which will be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state to the contrary notwithstanding. So they have to have, it has to be in law, and if they don't have any authority, then it's self-explanatory.
Okay, I think that makes sense, the way you explained it. I think people listening to this will understand what you're talking about. And again, I'm going to make this available when I get it into a form that's easy to read and use. Right now, my notes are not perfect, and I want them to be really as easy for you guys to use as possible. Okay, so you're going to sue in county court. You're going to file a pleading paper, and you're going to put your quo warranto, your writ of quo warranto, and the nature of the quo warranto in the top right caption of this pleading paper. John, can you
Yeah,
just clarify that real quick?
yeah. This is how you type it in the caption. Writ of quo warranto in the nature of quo warranto.
So you're going to spell out and the nature of quo warranto?
Yeah, yeah, in the nature of quo warranto.
Oh, in the nature.
Yeah.
And you're going to just literally like write that or type that up in the top right caption of the
You type that out. Yeah, type it on
pleading
pleading paper.
the pleading paper. And is a pleading paper like a formal document that you would download from the
Yeah,
internet?
yeah. All the courts expect that, and there's rules to show you how to get a pleading paper, and you just have to go through it.
And where would you find those rules? Is that in the court rules in your county law library?
Yeah, you could go to them and ask they're very helpful at the law library, the county law library.
That's
And
really good news. That's good
yeah,
news for Americans wanting to find information. Okay, and that's gonna come up a little later too. We're gonna use the law library in our counties and different parts of this process. So keep that in mind, guys. Okay, so you're gonna write quo warranto and you said in nature of quo warranto in the top right
yeah,
caption,
yeah,
and then you're gonna
in the nature of quo warranto.
in the nature of quo warranto. So okay, okay. And then you're going to put your chronology and your statement that we talked about earlier there.
Right.
And it's going to say how this public servant has failed and or refused to answer. And then that this public servant must therefore be removed from office for his rebellion to
Yeah,
the
yeah, you
Constitution.
have to notice and demand to the court that absent an answer to the contrary, he must or she must be removed from office.
And
And
you had
what you're
said, I'm sorry,
and what you're looking for is for the court to concur with you.
and they would write you back with a like we concur.
Well, they would just issue one, or they would not issue one.
Okay, by issuing some sort of removal.
Yeah, and so
Okay, like an order.
if the judge does not do that at the conclusion of the this court case, you send the judge a notice and demand for findings of fact and conclusions in law. And
Okay,
you know what
so
we
that's
said?
a step that we skipped last time. So if can you, for my clarity and for the clarity of the people listening, we've got a let me just find in my notes here. You're submitting your paperwork and then is this the same as the notice and demand to the court where you're the pleading paper with the writ of quo warranto on the top, like you said in the top caption and all that?
Yeah, it's to the right, top and the right.
So the notice
So on the left side will be a plaintiff or in the nature of it, and that's on the left half. And on the right half at the top is the that's the right caption
Right,
for
right. What
typing
I
in.
what I was asking was, is the notice and demand to the court that he or she must be removed, is that a separate document or is that the part of the pleading?
No, it's all part of the whole thing.
Okay, gotcha. So that's really important to file these things correctly. So the this would be part of the pleading paper. Okay, got it. Okay.
In the event that the court does not agree with you and doesn't go along with it, you then file notice and demand for findings of facts and conclusions in law. But you have to go through the court because of the supremacy clause. Again, it tells you, and the judges in every state shall be bound thereby. So
Okay,
holding
so
the
I
judge
just want to slow you
accountable.
down, John, because I myself am having trouble following that because you went kind of fast. Your brain's very full of knowledge, and I'm sure people listening are probably a little more confused than me because I've been talking with you for years now. So let's just slow that down a little bit. What I had in my notes is you're probably going to lose because of them not ever having to deal with this before, and them probably like you're not in their club, et cetera, like our friend, the former president, said once. Um, and so, is this where you would file then a notice and demand? And I did not catch what you said. A notice and demand for, can you please slowly
Yeah.
say that again?
Okay. Yeah. Notice and demand for findings of fact and conclusions in law.
In law. Okay. So that's your appeal.
No, that's before you get to the. No, after you, if you were to lose, they don't re rule in your favor, then you file that. A lot of times
Hmm.
everybody would put a motion, but no, I don't do motions because it's easy for them to deny it. They might even treat your notice and demand as a motion, and you got to tell the court, this is not a motion, this is a notice and demand.
Okay, perfect. That's important. And then where does the appeal come in? This is a whole new part that we didn't have in our original discussion. So when you file a notice and demand for findings of facts and conclusions in law after losing, is there a waiting period before you appeal? What goes between that and the appeal?
You're waiting, you're just waiting, you're waiting for an answer.
And then what? Once they give you an answer, they're probably going to say, we try to deny this or whatever.
Whatever they're going to say, denied or whatever, and you have to appeal it then.
Okay, and if they don't deny it, then what?
Well, great. Then they have to then I think it has to be removed. I'm not sure if it's the district attorney who does the actual removal, but
Okay, perfect. Then so the court basically, if they accept your notice for demand of findings of fact and conclusions in law, then they would basically order the removal.
right.
Perfect. So that would be in a perfect scenario. Likely though, you're going to have to appeal it. So let's go to the appeal. And this is where you kind of get into, um, there's probably very few lawful judges at this point. There's probably very few public servants at this point, according to you, John, that have filed or taken the required oath of office, which is just a frightening thought. Um, but anyway, let's not focus on the negative. Let's focus on the appeal. We're going to appeal with the same process and paperwork. Now, here's where the law library is going to come into play again, guys. You're going to go to your county law library and this is where you're going to find the rules for appealing. It's going to be called the rules of court. So remember that, rules of court. And that's just going to basically tell you how your county court likes to have things done. And so you can follow their rules for filing the correct way, appealing the correct way. I myself have dealt with this recently. And I was able to follow the procedure correctly, and therefore, it was efficient and effective, to just kind of go through. You don't want to get your stuff thrown out for a simple thing like missing a step, a basic thing, right? Okay.
Right.
So if you win your appeal, which I did, if you win your appeal, then you do what's called foreclose, which would be a writ of execution, and you would file
Well,
that.
no, 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 no,
No.
no, no. That's for a money judgment. Then
Yeah,
I
but
don't know.
that's what we had talked about though. Remember, John, we had gone through the whole part about the assets and stuff. So I'm going to go over that with people as well as the removal because that's what we talked about.
Okay, but
And
it's different if you have assets and then if you've been damaged and you want this first you want this person removed from office, and then you can apply for to the risk management for damages.
okay, so this is just I'm going to put this is just for a money judgment because really
Right.
We went through all that earlier, but like my whole goal is to get them removed. I'm not trying to get money, but you
Right.
guys, I'll include we're going to skip ahead. I will include this process for seizing their assets because that is important. Because these people operate on a lot of stolen assets in a lot of cases. We won't go into names, but that could be an avenue you want to pursue. I'm going to skip over that, but we will include that for you. So let's jump ahead then. John, can you help me find the spot we're jumping to? I think it's just the removal of from office portion.
Right. Right.
Um,
There's Kimmy, there's something I want to say. Well,
yeah,
it's fresh on my mind. They are not people. Their political status is they are not people. Their political status is they are public servants. And we should always call them, address them, public servant in their name, public servant, uh, uh, whatever. But you call them public servant first so they can get used to being understood and treated as what they are as a public servant. They are not one of the people, and we should not give them that title.
that's important too. Language is important here, and um, I'll talk about some government codes John shared with me just at the end briefly that you can look up if you are in the state of California that talk about that in more detail about like how they've sort of, you know, made us believe they've taken away our power, but that we in fact still do have it. So there's some codes you can go look at that would kind of talk about that more explicitly. So let's skip on to how would you get these people removed now that you've followed the procedure that we've covered thus far. And removal from office is really important because obviously these people are, if they violated their oath, they need to be removed. They should not be in office. The oath is required to hold office, right? Um,
Yes.
it looks like we've got about 10 minutes left in this iteration, so let's try to get through this. And I'm sorry about the time, but let's just kind of plow through this. So when you get stopped in this process, we're gonna have John to refer to. I will get some more information from him if needed, but John thinks that the district attorney for the county has to get involved with the removal. This would be a writ of quo warranto. This you had already submitted the writ of quo warranto, and you would basically get a finding from the court. So here's the step. You're gonna show the district attorney in your county. You're gonna show your county district attorney that you filed the writ of quo warranto and that the public servant hasn't answered and doesn't have the authority. Okay. Now, you're going to see what the district attorney of your county is going to do about it, right? They haven't been held, this public servant hasn't been held accountable yet. So the government codes I mentioned are for California, sections 54950 and 11120. And these explain how we gave public servants certain prerogatives and,
Yeah,
it's,
prerogatives.
yeah. Um,
Everybody says per. It's not, it's
it's
P-R-E,
my
prerogatives.
prerogative. But anyway, it's about regaining control over the documents, retaining control over the documents that we created and how public servants really they do not have the power that they have convinced us they do have over us. But like I said, that's kind of an aside. I want to pursue so you've shown the DA that you filed the writ and that this public servant hasn't answered and doesn't have the authority. And the DA now, you're putting the ball in the DA's lap in a sense of like seeing what they're going to do about it because it's their job at this point to do something to that you've requested that they do. So you're going to cite the state codes. And what we're going to do going forward is we're going to help you guys find those codes that are relevant to your state. Again, we're starting with California and Texas because that's where we are and we have the most kind of familiarity with, and it makes sense. But you're going to cite state codes to the DA in your request that the DA of your county enforce the law and have the public servant removed according to that law, right? The DA's oath is to support and defend in thought, word, and deed with their life, if need be, the Constitution of the United States of America against all enemies, foreign and domestic, because after all, they too are a public servant, right? So, how are you going to do this? You're going to submit a notice and demand. And in this case, we want them to do something. So it's not just a notice, it's a notice and demand. And we're going to say the demand is that they have the public servant who's violated their oath removed from public office. Now, according to the DA's job, the DA should prosecute and remove the public servant. So
Yes.
now the wording of this isn't exactly right. You don't have to go to court. You don't have to actually, you're not in a trial. You're not a witness. You're going to observe the court and you're going to make sure that it's carried out correctly. But Article
Well,
6,
actually,
Section,
excuse me, actually, you are a witness, but you're witnessing to what is actually taking place.
yeah, like when I said witness, I shouldn't have used that word. Basically, you're not being called to court. Like you're not
Yeah, you're
litigating at
not
this
being
point.
called to as a witness,
Yeah,
but you are witnessing what's taking place in
right.
court while your public servants are acting.
Yeah, and that's a good distinction. That's an important distinction to make. But I just want people to understand. Okay, so I know we're running out of time, so I want to get through this as fast as I can. So you're now handing the DA their job and you're telling them to do it, and they're going to litigate, they're going to prosecute, and they're going to have them removed. That's their job. Article 6, Section 2, Supremacy Clause means that the judges in every state are bound to do this. And you're going to need, they're going to do a court order. That's what you're going for, right? So you're going to one thing you can do is go in and see the DA in person. You might talk to somebody in his or her office and warn him to file and remove the public servant. And then you would provide all your paperwork that you've, you know, created and submitted so far showing where the public servant violated the law. And again, you don't have to go to court, but you probably want to see what's going on, and it's really important that you be a witness there and make sure that the process is carried out legally and correctly. The ruling is then where the sheriff would do the removal. And this is kind of something I want to turn it over to you just to tell us a little bit more. But John, we are running out of time unless we want to kind of do another meeting. But this has only been done in rare cases. I don't think we need to say too much about this because this is where we're at. But just I want to end with if the DA violates his oath of office and doesn't do his job of prosecuting and having this public servant removed, then you would repeat this entire process against him or her and
Yes,
keep going. So that's, in a nutshell, the process of wielding the oath of office to have public servants who have violated the oath removed.
right. And you cannot be timid and shy when you do this. You have to go there with the full strength and force what your intent is, and you tell your public servants what you want and what they are required to do according to the law.
Exactly. That's a really good point because we literally employ them. They work for us. We hold the power. And that's the thing that, I really wanted to clarify by providing this process so that Americans can take back that power. But it's like, how do you take back that power? What do you do? Well, this is one of the best ways I've ever heard of. And so I really hope this helps you. We're probably going to run out of time here in a few seconds, but thank you so much, John. I'm gonna follow up with, more work on this and we're not gonna leave you guys hanging. This will be, like I said, available on our website. Go to thevulturesbooklet.com and you can also reach us there. You can order the original booklet published in Oregon by Milt and read that. And you can use it if you live in Oregon. It's still viable. But if you want one for your state, you can reach out to us as well. But John, do you have anything you'd like to say before we close?
Yes, since this Vultures booklet was published in 2001, the criminals in charge have altered the oath of office, and they'll bring in, you want to be prepared for this, they will bring in a judge specifically for that one case. And they're going to be tricky, and you have to know how to handle them. But if you stick to the formula, the oath, the wording, and don't waver on it, and keep in mind that they are the servant, uh, and they don't tell us what to do, we tell them what to do. You have to mentally be strong and be forceful in doing this, not nasty or anything, but just you have to know who you are, and you tell them what to do, and you show them the law. And I've done that many times, and they a lot of times have collapsed.
Exactly. They are terrified that that you might actually know what you're talking about and know how to hold them accountable. So there you go,
Yeah,
guys. It's in a nutshell. The meeting's probably going to cut us off, but we somehow squeaked it in. I'm so excited to bring this to you guys, and we'll have more dialogue, and I'm going to have probably John do some blog posts and stuff like that. But thanks so much for listening, you guys, and we will see you again soon. Thanks a lot, John.
You're welcome.
All right. Bye.
Bye bye.